Hello and good morning, everyone. I'm Michael Higashi, and on behalf of Security and IDC, I'd like to welcome you and say thank you for attending today's webcast, Navigating the Perfect Storm of Personal Data for CCPA. Leading off the discussion today will be Ryan O'Leary, Senior Analyst at IDC. Following Ryan, Greg Martin, Solutions Architect, will be speaking today for security. Just a few housekeeping items before we get started. To ask a question, please click on the QA button that you see in the bottom of your panel rather than the chat. Please don't use the chat because the panelists and I will not see that. But you click on the Q&A and you'll get a pop-up. Type your questions and comments in the box and we will try to answer as many as we can as time permits. A replay of the recorded webinar will be sent following the webinar to watch on demand and to share with colleagues. And following the presentations, we will try to leave about 10 to 15 minutes for live Q&A. And with that, I'd like to turn it over to Ryan. Maybe perhaps you can do a brief intro to yourself to the audience first.
Sure. Good afternoon, good morning. Thank you so much for taking the time to out of your day to join us for this brief webinar. I'm Ryan O'Leary. I'm the Senior Research Analyst that heads up our worldwide privacy and legal technology coverage at IDC. I have been with IDC for a few years and am what I would deem a recovering attorney. So I bring a legal lens to this area. So briefly today, we're going to, if I can, there we go. Talk briefly about kind of where we're at in terms of data privacy, then jump into what CCPA is, why you should care, and then I'll close up by talking a little bit about the PrivacyOps before our friends at Security give you a much more in-depth look at it. So with that, let's get started. Our world is becoming more interconnected by the day. Almost every action we take creates new data, and the world of data is still largely unregulated. Sorry, we're having some audio issues. Is that better? Hopefully that fixes the audio issues. Gotta go back. Sorry. Our world is becoming, the world of data is still largely unregulated. IDC projects that there will be 102.6 zettabytes of data by the end of 2023. Now, if you're wondering how much data is, let's kind of put that in perspective, right? If we're talking in real world terms, if a gigabyte is a cup of coffee, a zettabyte is the amount of coffee that would fill the Great Wall of China. Then do that 102.6 more times. That's how much data we're grappling with in this day and age. And technology companies had a massive head start, and they were let loose on the data before the general public really understood what was going on, or really understood the consequences. Right? I mean, your Amazons of the world, your Facebooks of the world, really understood the benefit of aggregated consumer data a lot faster than the consumers did. Despite the whistleblowing by Edward Snowden around the NSA spying, it really wasn't until the 2016 election that the public, at least in the United States, really understood the gravity of the situation. It never really occurred to the average consumer what was possible with their data. Now we, of course, know, and regulations have popped up to try and handle the problem, but it's really a lot like putting toothpaste back in the tube. The sheer volume of data that's out there is just half the problem. The data is also spread out. Oh, what is happening? Sorry. The data is also spread out. The average organization utilizes more than 6 data centers around the globe. and the average organization has more than 3,100 endpoints. Knowing where the data is across the globe and organization is a monumental challenge, especially around data subject access requests under CCPA and GDPR. The other problem is this also creates a larger attack surface. 53% of organizations have experienced more than 3 reportable breaches in the last 3 years. Breaches that could now be potentially punishable by fines under the new data regulations. And they're doing all this with an average number of 92 IT employees and an even smaller percentage of security employees within that IT department. Unfortunately for these organizations, in the case of CCPA, these organizations did not have much input into the law. So let's briefly talk about what CCPA is. CCPA is the California Consumer Privacy Act. It was the product of a citizen-led initiative. This group was highly motivated. They were obviously seriously impacted by data privacy and found it to be a cause worth fighting for, and they were well funded, right? They got a question on the state ballot that was going to be even more restrictive than the law that was ultimately enacted. And the California legislature realized that this ballot initiative that would pass would be way more restrictive than any sort of law that they would be way more restrictive than any law that they could pass. And because of the way the California state legislature is set up, if it was passed via a ballot initiative as opposed to through the traditional lens, it would be harder to amend. So this law that was ultimately passed follows a good portion of the playbook that was set out by GDPR. The key requirements are very similar. The right to know and receive all the data that a company has on you, or the right to be forgotten, are very similar. The right to request that your data be deleted, but under CCPA, there are a few major differences, whether that's the right to opt out or the private right of action that consumers now face or can now exercise. So this is a pretty detailed slide, so I'm obviously going to let you guys kind of marinate on it. It's a comparison of CCPA and GDPR, the two most well-known data privacy laws. I don't think there's any argument from that. Right. As you can see, the similarities are substantial, but compliance with CCPA is a bit different. GDPR is enforced by the data protection officers of the various European states. And, I often use the analogy, it's much like when you're driving on the highway and you're going a little bit over the speed limit, right? You have to make that risk calculation of how many police officers will there be, versus the risk of going over the speed limit versus the risk of enforcement, right? That is kind of the GDPR story, right? There's only so much bandwidth that these data protection officers have within the various data protection organizations of the member states of the European Union, where unlike that, CCPA, however, has 2 enforcement mechanisms. The Attorney General can enforce provisions of CCPA, but under CCPA, in the event of a data breach, those violations can also be enforced by private citizens. And we already know that the plaintiffs' bar in California is motivated as they got the law on the books, and they also now get to enforce it. Because the enforcement bandwidth of CCPA is larger, this may make it a much more important compliance initiative, right? Because pretty much anyone whose data is impacted or breached under this law can now individually sue your organization. Another important difference, as mentioned on the previous slide, is the right to opt out of data sales. GDPR has no such right. And you need to be able to organize your data and make sure that once consumers have opted out of sales, you are not only not selling their data, but you're directing third parties to not sell their data as well, which is required under CCPA. So this begs the question, what are companies doing about it right now? This is some data from a survey we did in November, just before CCPA went into effect. Major organizations are unsurprisingly struggling with their data hygiene and information governance organization. Data portability is the biggest pain point overall as organizations struggle with knowing exactly where their data is, how to pull it in for production to a data subject, not to mention the added issues of validating an identity. Larger companies, if you look at the over 10,000 plus employee bucket, the purple line there on the left-hand chart, those folks are struggling with the breach notification requirement. Now, of course, CCPA does not specifically require data breach notification. However, it does punish data breaches. There is a separate statute in California that requires data breach notification, unlike in GDPR, which requires that you report a data breach within 72 hours of knowing of it happening. But data breaches offer a new, kind of issue, right? You have to make that determination. All the process that goes into a breach notification is you have to have the security mechanisms in place to realize that you've been breached, and then analyze it to make that determination as to whether it's an incident or a reportable breach. These are all huge issues. And then, of course, the right to be forgotten is another aspect of that data portability almost, or that data subject access request. So how are folks dealing with these issues right now? And right now, the answer is triage, but that is not going to last forever. They're heavily buying external services, and IDC expects that there will be an inflection point as we get more guidance on the rules and regulations. Continuously panicking and calling a plumber to come fix your pipes is not an effective way to handle everyday compliance, right? You need to drastically invest in internal resources and possibly even software. Corporate legal is starting to create operation centers around a number of functions. These centers are already doing eDiscovery and investigations with very similar workflows to data privacy. I would expect them to take over a significant portion of the data privacy compliance on the day-to-day. So what kind of processes and software will you need to think about? And that's where PrivacyOps comes in, which is a new kind of operations framework that we need to think about in terms of data privacy. Data maps are the bedrock. They're incredibly important. I often say data maps, data maps, data maps. Inventory your data. It's the base for everything that you do when it comes to information governance and data privacy. Data maps are not a one-time process. They're an iterative process, iterative process that needs to be updated regularly and almost continuously at this point. Consent management is another huge tool. You need to be thinking about how to track the do not sell and the cookies management, as well as manage your data subject access, your data subjects opt in and opt out. And then, of course, a huge one is third-party risk tools. We all have vast third-party networks. Recently, I was at a conference a few weeks ago. Recently, I was talking to some some major enterprises and their third-party vendor networks were all in the high five figures. Some as high as 89,000 third parties per enterprise. So you need to be creating that trusted ecosystem to kind of, eliminate as much of that third-party risk as you can. Cybersecurity as well. Cybersecurity is required by these laws. We also need to think about it forensically. At IDC, Cybersecurity Arrow is incident response and orchestration. It's analytics, incident response and organization. You need to think about it in order to figure out what went wrong with breaches. And if you don't have incident response and orchestration, it's tough to figure out what went wrong and make that determination as to whether it was just a breach or it was just an incident or whether it's actually a breach. And then, of course, there's the data subject access request tools that you need. Breaches are one thing, but data subject access requests are your data privacy contact with the consumer. The turnaround time required for these requests is tight. And there are a number of things you need to consider, right? Under CCPA, you need two ways to collect these requests. One of which could be a hotline. I would suggest having a hotline, a telephone hotline, right? Hotlines count as one. They are cheap, and phone calls are not as common as anymore as they used to be. If somebody is trying to enact their rights or submit that data subject access request, they're much more likely to shoot an email to privacy@insert company here email. You also need to, I would also have a form as opposed to an email, right? Because under CCPA, you can aggregate requests or have proxies file requests for you. So by having an email address, you're just opening yourself up to somebody sending you perhaps upwards of 10,000 requests or even more in a single attachment of an email. By having a form that you have to fill out individually each time, you can also, kind of show your consumers the unintended consequences of their rights and what kind of services or benefits they might be giving up by asking to be deleted. The other thing is these statutes have a high potential to be weaponized, so you need to make sure that only legitimate requests are coming through. So having strong validation and identity validation practices around your data privacy requests is important as well. And finally, transparent data policies and practices. Those in this day and age, terms and conditions buried in 20 paragraphs of tiny text are no longer cutting it. So in order to kind of build trust for your organization, transparency is key. So let's talk about that PrivacyOps workflow that I've mentioned PrivacyOps a few times. Digitally transformed enterprises are emerging. Your organization needs to be moving towards an intelligent core of your business applications where data feeds platforms to enable digital tools. Siloed organizations cannot hope to digitally transform enough to even think about practicing privacy ops. You must break down the silos of your organization. Data privacy is enabling this in a way by causing a convergence of the responsibilities of compliance, legal, and security. And you need that convergence to happen so that you can much more easily implement a common framework to use modern tools like machine learning to automate. And if you automate your privacy workflows, you can get as close as possible to real-time data subject access request compliance. You could potentially even create just a portal where somebody could manage their own data subject access, such as, the do not sell, the right to be forgotten, as well as the benefit of severely limiting your exposure under the law.